My name's Jeff Morgan. I'm from Dallas, Texas. I want to revisit the ruling that Tyrant Judge Mary Brown made against Jeff Younger. In this case, DF 1509887 Anne Georgulas versus Jeffrey Younger. I want to look at this memorandum ruling, and I also want to look at the ex parte temporary restraining orders and compare it to what Attorney General Ken Paxton wrote in 2019 about the fundamental rights of parents. So first off, we look at, again, Mary Brown, the 301st Judicial District. She rendered this opinion on August 3rd, 2021. She basically told Mr. Younger he had to pay money for the attorney's fees and give them to Anne. She also gave further temporary orders, which basically stripped Mr. Younger, of his parental rights. What she said, and a lot of this stuff was done without any evidence. It was basically done by pleadings and allegations. There was nothing that was there. She gave exclusive right to Anne to establish a primary residence, to make medical, dental, and surgical treatments involving certain procedures, to consent to psychiatric and psychological treatment, to get child support, to consent to all medications given to the children, to represent the children in legal action, to consent to marriage and enlistment in the armed forces, make decisions concerning the children's education, make decisions concerning the children's haircuts, the services and earnings of the children, to act as an agent of the children in relation to the children's estates, to manage the estates of the children, to sign up for the children up for extracurricular activities. She was given this exclusive right. Now, when you give somebody an exclusive right, when you give one parent an exclusive right, what you are actually doing is you are taking away the right of another parent. You are violating his or her fundamental right as a parent. So with all of these things that Judge Mary Brown found, she was saying, I'm going to take this right away from you, Mr. Younger, and give this right to Anne Georgulas. Now, Anne Georgulas is not the biological mother of the children. Mr. Younger is the biological father of the children, but Anne Georgulas is not the biological mother of the children. But according to Tyrant Judge Mary Brown, that's okay. We're going to give all of these rights to the pediatrician, and I would say the confused pediatrician, Anne Georgulas, and we will strip them away from Mr. Younger. And then she talks about counseling and any idea that Miss Georgulas must notify Mr. Younger of doctors, counseling, or mental health appointments or extracurriculars for the activities for the children, they're lifted. They're gone. They're done away with. These are now exclusive decisions of Anne Georgulas. And then she gives this thing here: in an effort to ensure the emotional well-being and physical safety of the children, the court orders that all of Mr. Younger's possession periods shall be continuously supervised by forensic counseling services at Mr. Younger's sole cost and expense. This is completely ridiculous. Mr. Younger has been having parenting times with his children for the last year and a half at least, and he's been having much more than what this tyrant judge Mary Brown is doing. This is a very arbitrary, capricious ruling by Mary Brown. It is tyrannical, and it violates the fundamental rights, the fundamental parental rights that are given to Mr. Younger and guaranteed by the 14th Amendment of our Constitution, which I will get to in just a moment. She also ordered the appointment of Stacey Dunlop as an amicus to ensure the safety and welfare of the children and that their best interests are being served. This, again, is complete nonsense. This is financial plundering of both Anne and Jeff. Both parents are ordered to pay a $5,000 retainer for the services of Mr. Dunlop, which I am not sure if they want or not, but regardless, they should be able to make this decision, not this tyrant judge, Mary Brown, and they have to pay 50% of the amicus fees each. And then if you look at the temporary restraining order that was filed by petitioner Anne Georgulas, here's what else happened. The possession or access of the children, both to James and Jude, is ordered by the court to be strictly supervised by a supervisor designated by petitioner. In other words, Anne gets to make the sole decision in this, or the court. This, once again, is completely tyrannical. What they are doing is they are depriving Mr. Younger of his fundamental right to parent, but they're saying that one parent will have this opportunity to do so, or the court can do this. And then also that Anne Georgulas is permitted to withhold information from the respondent. And instead of saying the respondent, let's say this: the father. Anne Georgulas is using the courts to exert her will upon Mr. Younger. That's all she's doing. And the courts have to always find business, drum up business for themselves, so they're very happy to come in and pretend that they are going to be super parent. This is an abuse of the judicial system. And of course, Tyrant Judge Mary Brown decides that she wants to be in on the action. So she says, Miss Georgulas, you are permitted to withhold information from the respondent, the father, Jeffrey Damon Younger, regarding the children's extracurricular school activities, school functions, school enrollment, counseling, and medical care until further orders of the court are entered. Moreover, how was this done? Was there any proof of any of these things? No. If you take a look at the extraordinary relief, because it's extraordinary relief, it says that the court examined the verified pleadings and allegations of the petitioner. This is very important to know. You don't have to tell the truth. You can just plead something, you can make something up, you can allege something, and the court will look only at that. The court won't look to say, well, is this true, is it not true? They will look at the verified pleadings and the allegations of the petitioner, and they make a conclusion based on an allegation. Even if it's a false allegation, the court will base its conclusion on a false allegation rather than the facts. But because this allegation is being alleged by Anne Georgulas, the non-biological mother of the children, and she says that by letting Mr. Younger have unsupervised visitation, that would place the children in imminent harm and endanger the children's emotional and physical well-being were the children to remain in his presence. Now think about what's going on here. Because at this point in time, Anne Georgulas is trying to socially transition a boy into a girl. James Younger is a boy. His birth certificate says that he is a boy. His legal name is James. If you look at his chromosomes, they are male. They're male chromosomes. There is nothing about James that is a girl. And yet, Anne Georgulas wants to transition James into a girl, at least socially, and possibly later on try to schedule him for some type of chemical castration. She wants to counsel him so that James can be and act as a girl. And you're going to tell me that that's looking out for his emotional well-being? The fact that he's a boy, she's going to make him lie, present him as a girl. She's going to dress him up as a girl. She may put dresses on him, lipstick, whatever it may be, hair braids. She's going to do all of this stuff. And somehow Anne Georgulas is looking out for the emotional and physical well-being of James. And then there's Jude, who was his brother. Jude knows that James is a boy. He's a boy. And Jude has to lie to others and tell others that my brother James is a girl and that his name is not James but it's Luna. This is insane. But this is what Tyrant Judge Mary Brown is doing, and this is what our family courts do all the time. Based on pleadings and allegations, no proof is necessary. You can lie to the court, and the court will accept your pleadings and your allegations. Now, what I want to do is examine this in light of KP0241, an opinion rendered by the Attorney General's Office on February the 22nd, 2019, and this was in response to a question by James Wright. What standards shall the court apply when balancing the rights of the state against the fundamental rights of parents to raise their children free from government intrusion? So remember, the underlying premise here is that parents should have fundamental rights to rear their children, to raise their children free from government intrusion. But the state every so often thinks that, well, we have rights to tell you what to do. So the Attorney General's Office actually laid out the whole process to Representative James White and said this. First off, the issue is a due process clause of the 14th Amendment, which protects fundamental parental rights. The courts have long held that the natural right existing between parents and their children is of constitutional dimensions. The child is not a mere creature of the state, and those who nurture him and direct his destiny have the right, coupled with a high duty, to recognize and prepare him for additional obligations. The interest parents possess with regard to their children is a fundamental liberty interest protected by the Due Process Clause of the 14th Amendment. So one thing I want to notice is that the natural right of existing between parents and their children. And it's not one parent. We don't get to say, well, one parent has this natural right and the other parent has no right. The child was made by two people. Both are parents. they both have the right to direct the upbringing of their children, free from government intrusion. This is a constitutional issue. It is a fundamental right. The courts have recognized the jurisdiction of the state stops here. You do not go into the parents. Even if you think you could make a better decision on behalf of the parents, you can't do so. This is a parental right issue. And furthermore, the due process clause says that no state shall deprive any person of life, liberty, or property without due process of the law. The court has held that this clause includes a substantive component that forbids the government from infringing upon certain fundamental liberty interests at all, no matter what the process is provided, unless the infringement is narrowly tailored to serve a compelling state interest. So one of the questions I want to ask then is, what is the compelling state interest here? That Mr. Younger be excluded from his children's life? That the biological father of the children be excluded from their lives when a non-biological mother alleges things that are not proven? And Tyrant Judge Mary Brown says, well, I'm going to go along with this. The court has held that fundamental rights are protected by the due process clause. But remember, this is family court. In family courts, you don't have to worry about due process clause. You don't have to worry about constitutional rights. You don't have to worry about fundamental rights. Family courts do whatever they want to do, just as Tyrant Judge Mary Brown does right here. And the interesting thing is, when I call Tyrant Judge Mary Brown a tyrant judge, some people probably think, man, you're being harsh. Why do you call her a tyrant judge? She's just doing her best. She is violating a fundamental right protected by the due process clause, and she thinks that she is above the Constitution, evidently. So is that not the work of a tyrant? A tyrant that says, screw the Constitution. I'm in my court. I am God. Liberty includes the right of the individual to establish a home and bring up children, and yet she has given that right to the non-biological mother, Anne Georgulas. Due process protects the right of parents to make decisions regarding the care, custody, and control of their children, and that has been deprived to Mr. Younger. And this, again, is the right of parents, not just one parent, parents. But Tyrant Judge Mary Brown wants to say, no, I'm going to give this to one parent and take it away from the other parent. The due process clause protects the right of parents to direct the upbringing and education of their children. And yet Tyrant Judge Mary Brown has said the exclusive right goes to Anne Georgulas, the non-biological mother of James and Jude Younger. The due process clause protects the rights of parents to make medical decisions on behalf of their children, but not in Tyrant Judge Mary Brown's court. Tyrant Judge Mary Brown says that the exclusive right to consent to medical, dental, and surgical treatment involving invasive procedures, except for the hormonal stuff, and the transgender surgery, that goes to Anne alone. So what she is doing is saying that the rights of the parents only go to one parent, the parent that she designates. And the other parent, well, screw him or screw her. And yet the due process clause protects the right of parents to make medical treatment decisions on behalf of their children. Furthermore, the due process clause, coupled with the First Amendment, protects the right of parents to guide the religious training and education of their children. Well, when you put somebody under supervised visitation and you give them 2 hours during the week, and then you give them 6 hours on the first, third, and fifth weekend, I believe it's 6 hours on Saturday and 6 hours on Sunday. I don't remember the exact numbers that are involved here. But you cannot direct and guide a child's religious training and education when you have that little time and when you are being supervised by a supervisor that you have to pay for. And yet the due process clause protects the right of parents, including the biological father, and I would say probably the biological father even more so than the non-biological mother, to guide the religious future and education of their children. Moreover, as a general matter, the courts apply strict scrutiny to review state statutes that infringe upon fundamental parental rights. So the underlying principle here is that as parents, you have fundamental parental rights. Now, the state wants to be able to infringe upon your rights from time to time. So the Constitution says, well, wait a minute here. You just can't do this willy-nilly, because if you do this anytime you want to, the children belong to you, not to the parents. We have a thing called fundamental parental rights, and the court said certain rights belong to the parents. But we as a state, we as Tyrant Judge Mary Brown thinks I can make a better decision. Sorry, you cannot do so, because this right belongs to the parents. And I would argue even more so the biological parent as opposed to the non-biological mother, and that you just can't come in and make a decision like that. So if you go back to 2000, the Supreme Court's opinion in Troxel versus Granville, it contains the most recent expansive discussion of fundamental parental rights. And what Troxel said is this: if a parent adequately cares for his or her children, i.e. is a fit. So the definition of fit is that a parent adequately cares for his or her children. It doesn't say that the parent must be the best provider in the world or the best. If the parent adequately cares for his or her children, that is a fit parent. And there will normally be no reason for the state to inject itself into the private realm of the family to further question the ability of that parent to make the best decisions concerning the rearing of that parent's child. Once again, you have a biological father versus a non-biological mother. And I would think if based on that alone, the biological father would have precedent over the non-biological mother. But in this case, what Tyrant Judge Mary Brown says is, screw all of you. I am the one who knows best I can make the best decisions regarding the rearing of the children. Furthermore, both federal and state courts generally apply strict scrutiny if a state statute infringes upon a fundamental liberty right protected under the Due Process Clause of the 14th Amendment. Why is this important? Because strict scrutiny is the highest level of scrutiny that must be applied if you are going to deprive somebody of his or her fundamental rights. You cannot just use a whim. Well, I just think it would be better if only the mother had the rights here. That is not strict scrutiny. So it turns out that Tyrant Judge Mary Brown is violating the strict scrutiny that she must use if she is going to deprive a parent of the fundamental liberty right, which is protected by the Due Process Clause of the 14th Amendment, which once again goes to show that in family courts, anti-family courts, with anti-family judges like Tyrant Judge Mary Brown, they don't care what the Constitution says. They will do whatever they want to. They will violate the Due Process Clause of the 14th Amendment at will, because that's what their whim says. Strict scrutiny requires the government to prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. So, number one, Mary Brown, Tyrant Judge Mary Brown, has not even stated what the compelling interest of the state is. That she has now restricted Mr. Younger's rights to his children, and she certainly has not narrowly tailored her ruling, even if she could prove the former. She has not narrowly tailored her ruling to achieve that interest. So Mary Brown, Tyrant Judge Mary Brown, is in violation of the strict scrutiny standard, which requires the government to prove that the restriction that she is imposing furthers a compelling interest and is narrowly tailored to achieve that interest. It must be narrowly tailored. The infringement upon the parental rights must be narrowly tailored. Tyrant Judge Mary Brown is broadly tailoring her ruling to infringe upon Mr. Younger's parental rights, fundamental parental rights, fundamental liberty rights. So going down to the third point here, certain context regarding child custody determination may, and the operative word here is may. It's not saying that it has to, but it may warrant the application of additional standards. And here we go into, first off, when a court resolves disputes concerning conservatorship and possession of a child, the court bases those decisions on the best interest of the child. This is complete nonsense, because nobody even knows what the best interest of the child means. This is what the court uses to take umbrage. This is what the legislators use to say, well, we're talking about the best interest. And everybody says, oh yeah, the best interest of the children. They don't even know what it means. Nobody knows what it means. I've talked with judges. I've talked with legislators. I've talked with individuals. Nobody knows what this means. It is a nebulous thing, so it gives the judge discretion to make up whatever he or she wants to. When parents are presumed to act in the best interest of their children, in situations involving divorced parents may have differing opinions regarding what is best for the children. Well, parents in a intact family may have differing opinions regarding what is best for the children. This is complete BS because the same thing does happen in intact families. Whether it's an intact family or a divorced family, you have two parents. One person may think this is the best interest of the child. Another person may think that is the best interest of the child. But what is interesting is this. A judge is not allowed to come in and say, I'm going to overrule both of you. I'm going to put something in place that both of you have to adhere to because I actually know what the best interest of the child is. This is a situation that should only be resolved between these two parents because the parents decide what is so-called in the best interest of the child, whatever that means. Now, here is where the legislature gets confused. The legislature has established the standards by which courts must resolve those disputes. The best interest of the child shall always be the primary consideration of the court in determining the issues of conservatorship and possession of and access to the child. This is nothing but a cowardly decision done by the legislature. It is one of the most cowardly and irresponsible things that the legislature could do. Why do I say that? Because the best interest of the child standard is a lie. Nobody knows what it means. It sounds nice. It is a lie by which you snooker the public. And I'm going to take this one step further. Say, for example, in the issue of no-fault divorce. First off, you say you have no-fault divorce. While they couldn't get together, they couldn't keep their marriage together, it's no-fault divorce. Really, no-fault divorce often is forced divorce, unilateral divorce, divorced on demand, divorce for any reason, for no reason. Everybody knows, the majority of people know, no-fault divorce is a lie, point-blank lie. Usually there's something that's going on there. One person doesn't want to accommodate his or her spouse. One person's has maybe in an affair. One person might be doing something completely different that would violate the covenant of marriage. But that's not no fault. Those are fault-based reasons. It is absolutely ludicrous to have no-fault divorce and then talk about fault-based parenting. You have no-fault divorce, forced divorce, divorce on demand, and then you say, but now we're going to determine child custody by finding fault in somebody's parenting. We are going to use fault-based parenting to determine what is in the best interest of the child. That is complete garbage and crap. The legislature was cowardly. They lied to the public, but they snookered the public. So the Texas Supreme Court, and we've talked about this issue of the best interest of the child, and one of the legislators, Anna Maria Ramos, who by the way is a divorce attorney, but who also serves on the Juvenile Justice and Family Issues Committee, she is sure that she knows what the best interest of the child means. This is objective as can be, and she talks about the Hawley factors. But one thing that I find is very interesting is this is a non-exhaustive list of factors. So where is the exhaustive list? They're giving, this is some representative factors supposedly that determine the best interest of the child. This is crap, complete crap. It is a non-exhaustive list. We don't even know what the exhaustive list is. So this is, the Texas Supreme Court actually failed miserably here. By saying that, well, I'm going to use these Hawley factors, this non-exhaustive list of factors, to ascertain the best interest of the child. What I want to know is this. Can this Texas Supreme Court, can our legislatures guarantee with 100% certainty that whatever the judge decides is in the best interest of the child? Would they be willing to be sued if it's not in the best interest of the child? Would they be willing to have their property taken from them? Would they be willing to pay for the damages that would take place if it were not in the best interest of the child? Of course not. This is legal nonsense. There's no description. There's no objective standard to determine the best interest of the child. This is cowardly. It was irresponsible by the legislators to say this. It was a complete snookering of the public, and it's just as irresponsible for the judges to invoke this, because there is not one judge that I've ever spoken to that has said, I know what the best interest of the child is. Well, it's interesting because they don't know what it means, but they somehow make determinations in light of the best interest of the child. My definition of the best interest of the child is clear. The best interest of the child is to be reared in an intact home with his or her natural mother and father, and we hope that they're surrounded by strong relatives and a society that support and the value of marriage. That is my definition of what the best interest of the child is. Now you might say, well, that doesn't apply in every instance. Okay, it doesn't apply in every instance, but it applies in the vast majority of instances. And your definition of the best interest of the child applies in no instance. It's just a made-up standard. So my standard is much better than the Texas Supreme Court standard, because the Texas Supreme Court standard, they have no clue what they're talking about, and the judges have no clue, and the legislature has no clue. I can tell you that based on research, based on studies, based on general life outcomes, the best interest of the child is to be reared in an intact family with his or her natural mother and father, and we hope to be supported and surrounded by a strong extended family and by a society that supports and values the institution of marriage. Period. The Hawley factors, they say the best interest of the child is a proper and feasible criterion. This is garbage. It is complete garbage. It's improper and it's unfeasible for making the decision as to which of the two parents will be accorded custody. You could have a parent who is breaking the marriage contract, who is leaving everything, doing everything to try to destroy the marriage, and then he or she gets the children. It's absolute nonsense. Or, as I've said many times, the technical term is this is crap. And it's very interesting to me how it turns from resolving a dispute regarding conservatorship and possession of a child, and then it goes into permanently severing parental rights. What is this talking about? Why do we go from one down to parental rights? I think this is nonsense completely. But before a state may sever and completely and irrevocably, look at this, completely and irrevocably, may sever completely and irrevocably the rights of the parents in their natural child. Due process requires that the state support its allegation that support termination by at least clear and convincing evidence. And clear and convincing evidence is not the same standard as strict scrutiny. Strict scrutiny is you've got to really lay out your case. Clear and convincing evidence is not that high. It's kind of like the medium level of evidence. So you can have your parental rights taken from you, just as perhaps Tyrant Judge Mary Brown is doing right here to Mr. Younger, based on so-called clear and convincing evidence, which is not very clear and it's not very convincing, because Mary Brown, Tyrant Judge Mary Brown, is actually suspending Mr. Younger's parental rights based on pleadings and allegations that have not been tested. They are just pleadings and allegations, and she is exercising her will in this matter. This is complete judicial tyranny. This is something that we need to stand against. But once again, in family court, the Constitution does not apply. So, consistent with the U.S. Supreme Court case law, the legislature included the clear and convincing standard into the family. This, again, is crap. Completely crap. The state has to prove its case as to why it can even infringe upon a fundamental right of a parent to rear his or her children, and yet by the family code has decided, well, maybe that's too hard, so we're going to use clear and convincing evidence to sever a parent-child relationship. This is a statutory law that violates our constitutional protections. But the interesting thing is here is that in point C, the courts presume that fit parents act in the best interest of the children. And what is a fit parent? A fit parent is one that basically provides for his children. The courts presume that fit parents act in the best interest of their children and refrain from imposing their own judgment in lieu of a fit parent's decision regarding what is in the best interest of the child. Again, the best interest of the child is nonsense, but what I want to focus on right here is that the courts shall refrain from imposing their own judgment in lieu of a fit parent's decision regarding what is in the best interest of the child. The burden of proof is upon Tyrant Judge Mary Brown to show that her judgment, that her ruling upon Mr. Younger is allowed to even be given, because she should be refraining from imposing her judgment over his judgment. If Tyrant Judge Mary Brown wants to declare Mr. Younger an unfit parent, that is a whole different discussion, a whole different story. That is not what has happened here. Tyrant Judge Mary Brown is merely imposing what she thinks should happen, what she wants to have happen. Maybe she's been bought off by the Kuntz Fuller law firm. I don't know. Maybe she's been bought off by Anne Georgulas. I don't know. Maybe she's a subscriber to the LGBTQ philosophy and the transgender philosophy. I don't know. But she has not met her obligation, her duty, as far as what she is doing to impose her judgment upon a fit parent, because Mr. Younger is a fit parent. It has not been proven otherwise. What she has done is completely illegal, completely wrong, and she should be reprimanded for that, and because she does this on a continual basis, I believe that she should actually be removed from office for this. The state may not infringe upon the fundamental rights of parents to make child-rearing decisions simply because a state judge believes a better decision could be made. Tyrant Judge Mary Brown evidently thinks a better decision could be made. But according to this Attorney General's opinion, the state and the state's actor, Mary Brown, Tyrant Judge Mary Brown, may not infringe upon the fundamental rights of parents to make child-rearing decisions. And again, the operative word here is parents, two parents. I would think that probably a biological parent has priority over a non-biological mother, but that's my opinion at this point. I don't know about that. The summary of KP 0241 is this. The Due Process Clause of the 14th Amendment protects certain fundamental parental rights, including the right of parents to make decisions concerning the care, custody, and control of their children, to direct the upbringing and education of their children, the right to make medical decisions on behalf of their children, and in conjunction with the First Amendment to guide the religious future and education of their children. It does not say of one parent's children, it says of their children. And that's why Tyrant Judge Mary Brown is completely violating this, and that's why I do call her a tyrant judge. Courts review governmental infringements upon fundamental rights protected by the Due Process Clause under strict scrutiny. And that requires the statute serve a compelling state interest and be narrowly tailored to achieve that interest. How is her ruling narrowly tailored? It is not. How does that serve a compelling state interest? It does not. And I don't even know what the state interest would be at this point. The legislature has established this, but once again, the ignorant legislature has established their murky and confused guidance. This is not a standard. This is guidance, and it's murky and it's confused and it's ridiculous. The best interest of the child, it is nebulous. The definition is nebulous. It is undefined. It is totally subjective. But they say the best interest of the child will always be the primary consideration of the court in determining the issues of conservatorship and possession of and access to the child. Parental rights are fundamental. And even in the situation of divorce, you cannot deprive a person of fundamental rights if there is no reason for that person to be deprived of fundamental rights. And yet the legislature, in their confused manner, has said, well, that's okay, we can do that. No, it's not. And what I would say is that the legislature needs to live under its own legislation that it's put out there. And I think that what that would mean is that we as parents should be able to tell the legislature, you know what, we are going to subject your children to the best interest of our consideration standard. Whether you want us or not, it makes no difference. Because when you go through the issue of divorce, the state sides with one person. It's always the petitioner 100% of the time. It's always the petitioner. And that person often is the person who gets conservatorship and possession and access to the child. The other person almost always gets child support obligations. That's what they call it, the child support obligations. That's the way that you become a good parent, is by providing child support and by becoming a visiting parent. The whole family code violates our Constitution. Tyrant Judge Mary Brown violates our Constitution. She is a tyrant. And basically, instead of permanently and irrevocably terminating Mr. Younger's parental rights, what she is doing is temporarily terminating his parental rights. And I would argue probably she's doing this to lay the foundation to do this permanently. The Kunstfuller law firm, well, there's no doubt in my mind that they will do this if they think they can make money from it. They don't care. And the child castration attorney, Jessica Janicek, she would be the first one to be up there and to be the defending Anne Georgulas. The courts presume that fit parents act in their best interests of their children, and the courts refrain from imposing their own judgments in lieu of a fit parent's decision regarding what is in the best interest of the child. Tyrant Judge Mary Brown has violated this very clear obligation that she has. She has imposed her own judgment, and that's why Tyrant Judge Mary Brown should be removed from her position as judge, and Mr. Younger's rights should not be stripped at this point in time, unless you can prove him to be an unfit parent. And the same standard should apply to Anne Georgulas. If the non-biological mother, Anne Georgulas, who wants to transition a boy to a girl socially first, who wants to present a boy as a girl to the public, who wants to dress a boy up in dresses, who wants to confuse the other son, and by saying, why do I have to lie about my brother when I know he's a boy? Why do I have to call him a girl? Why do I have to lie to people? If she is acting in the best interest of the child, we are in a very sad state of affairs in the state of Texas. I would argue that that is child abuse, and perhaps actually that might be the cause of terminating her parental rights. She should be subject to the exact same thing that she is subjecting Mr. Younger to. I also believe that because of the financial harassment that's going on here, because they continually force Mr. Younger to pay and pay and pay for this, they know that all they are doing is creating money for themselves. I believe that as well that we should be looking in and investigating these law firms. We should be investigating the judges. We should be investigating the law firms. We should be investigating the attorneys. And we need to overhaul this entire system that we are suffering under, this tyrannical system, best exemplified right now, today, by Tyrant Judge Mary Brown. Thank you.